Are non-compete agreements illegal in Minnesota? I'm Aaron Hall from aaronhall.com. Please see the disclaimer below. I'm often asked, are non-compete agreements illegal in the state of Minnesota? The answer is quite simply no. A little background might be helpful. States like California have largely made non-compete agreements illegal in the employment context. That means, for example, if an employer wants a California employee to sign a non-compete, the general rule is, even if they sign it, it's not enforceable. And then you have states on the other end of the spectrum. Delaware, for example. Delaware has a history and a reputation of enforcing the right to contract, which basically means, look, parties have a right to enter into an agreement. And Delaware is much more hesitant to trump those agreements of parties for public policy reasons. Minnesota is more in the middle. The general idea in Minnesota is that a non-compete agreement is enforceable between an employer and an employee, but the court will make sure that there's been a balancing of the employee's right to earn a living and the employer's right to protect their interests. Let me give you a couple examples. If an employee is a hairstylist and the owner of the salon has asked the stylist to sign a non-compete that says they will not operate a salon anywhere in Minnesota, that geographic scope is probably too broad, because let's think about it. The salon probably doesn't draw employees from more than a few miles from its location. So that would not be enforceable to that extent, that geographic extent. But here's another example. Let's say the CEO of a national or international company is being asked to sign a non-compete that says they won't work for a competitor in the entire United States. Well, there's nothing about that scope that would necessarily be illegal, because if you think about it, the employer has an interest in protecting their property, their information, and their ability to compete effectively throughout the entire United States. I'd say, as a rule of thumb for most employees in Minnesota, a non-compete will be enforceable throughout the entire state, but if you try to cover multiple states, the employer must have a pretty good reason for that. Now, there are other limits on the scope of a non-compete agreement. For example, how long is it in effect? 2 years has been found enforceable. Often 10 years or 20 years or lifetime, that's not enforceable. And very commonly 6 months or a year is enforceable. What we've been talking about today is, are non-compete agreements enforceable in the employment context? I should note that there's a big exception for independent contractors or when a business owner sells a business to another. Those are examples when much broader, longer non-competes are enforceable. The courts look at those and go, look, the owner of a business should know enough and realize that, oh yeah, it makes sense that if they sell their business, they shouldn't be able to turn around and compete 3 years from now, for example. If you have other questions, feel free to leave them in the comments below. And to learn more information, visit the article referenced below at aaronhall.com.